I am Michael Eisenberg. I chair the Information Security Committee within the American Bar Association, and we are privileged to again do what we've done for about a decade and bring three very senior, experienced attorneys who are members of and have been past chairs of the section of Science and Technology Law of the ABA and actively involved in information security throughout their careers, to bring them before you to begin the law track of RSA with a session that's designed to tease out several important topics that are au courant, important to the profession, important to the industry, and also give you a couple of news headlines of things that are so recent that they didn't have time to make the final publication of our slide set. So without further ado, I'm going to begin and then turn over the microphone to Cindy Zwick, who will be addressing AI. Following her, Lucy Thompson is going to do the C-suite and the impact of a number of developments in regulation on the behavior of our industry as a community. And finally, Ruth Brough is going to address surveillance society and privacy issues. Let me quickly turn you to the top of the news. The top of the news, from my perspective, where are we in the slides? Thanks. The top of the news is the emergence on March 1st of the administration's new national cyber strategy. And that artifact, a 17-page document, is the culmination of several years of hard work by a diverse array of communities within the administration, from virtually every agency, the intelligence community, the defense community, and other parts of the national security community, and as well as the civilian agencies, particularly DHS, laying out a roadmap of aspirational policy for this administration and the agencies of government over the next years. And it's certainly not the first national cyber strategy to have been published. It won't be the last. What's significant about it in its 17 pages is not so much its content, in my view, but in the response that it elicited within 48 hours. Those 17 pages produced about 1,700 news reports and critiques. But there are two areas of it that are significant, and the most important of it, it's divided into what they call 5 pillars, and 2 of the 5 I consider most important and commend them to your attention. The first is the approach that it is largely aspirational, and it heavily defends the fact that it's aspirational, and many of its proposals would depend on policy change, more properly done by the Congress, but likely to be the basis for executive order activity going forward. And the substantive issue of most interest is its discussion of the long-standing concept of public-private partnerships. I personally believe the last effective public-private partnership in our sector was Sematech, and that was a long time ago. There have been many public-private partnerships that have devolved into charter and marching societies since then. The objective of public-private partnership reform, as set out in this national cyber strategy, is to have effective operational change in the way the government and industry act to address cyber challenges, to address the proliferation of adversarial cyber attack behavior, and other major issues that are confronting the industry. So I highly commend not only the NCS, but much of the commentary, including an excellent lawfare summary that came out 2 days after its March 1st release. The next item that I want to call to your attention are the 2 Supreme Court cases dealing with Section 230 and the role of carriers and their obligation for content. The Gonzalez case and its companion in the Supreme Court that were briefed about 6 weeks ago. They are, if the court follows the plaintiff's view on both of these cases, potentially in a position to change policy on the responsibility that those who, both in social media but in other vectors as well, carry content and what it means to be responsible when the content you carry is false, untruthful, or has other consequences that might result in liability. Those of you who are court watchers or interested in judicial opinion, I highly commend those to you. If you're in the social media, I'm sure your general counsels are paying close attention. There's another issue that I am going to be the sponsor and host for a Birds of a Feather session at 1:20 on what is known as the new due diligence. The Uniform Law Commission, the people who brought you the Uniform Commercial Code, has been teasing around the edges of changing the recommendation policy that goes to the state governments and can change the way transactions happen. And we're going to talk about a view that technology transactions are driving a new understanding of due diligence and a transformation of the traditional concept of caveat emptor, buyer beware, that may have profound implications for the way technology buyers and sellers interact with each other. Two very recent things that I didn't have a chance to get into the slide that most of you are probably aware of if you've been paying attention to the news are the Teixeira leak, which some of the news outlets have treated as if it is a profoundly novel episode, but in fact, my view is that this is part of a continuing concern that we have with the twin pillars of a problematic situation of massive overclassification of documents within the repository of the U.S. federal government and its many agencies. At the beginning of the Obama administration, there was a projected plan to declassify 34 billion pages of overclassified documents. They never got around to doing that. That number of potentially overclassified documents is huge. But after 9/11, we also increased the number of holders of top secret clearances across the government by 1.2 million people. And as someone who continues to hold a TSSCI, I can say supervision is not even across all of the agencies who employ many of those people. And Mr. Teixeira getting access and being able to exfiltrate and disseminate documents is probably not an isolated episode, and that entire space needs addressing. The news coverage of those is something that I commend to you in order to get a wide view of what's going on. Finally, the press has in the last days carried a report coming from a NGO that has gone into the Ukraine and looked at crashed Russian military artifacts and discovered a large number of US branded microprocessors in those artifacts. It raises the issue of where are those microprocessors coming from, getting into the hands of the Russians, how is our export control system working, and is it something that many have contended for years continuously needs monitoring and reform. So those are the headlines from Washington. If you have questions, happy to address them after the session is over. I'll stick around. But I want to turn the microphone and the session over to Cindy for her dive into AI.
Thank you, Michael. Do I need to turn this off or? Okay. Good morning, everyone. It's my honor to be able to speak with you for the next few minutes about a topic that certainly has been in the news, artificial intelligence. It certainly does have the potential to transform just about everything. In particular, recently, a lot of progress has been made with regard to generative AI, which refers to a category of AI that generates new outputs based on the data it's been trained on, as well as prompts from the users. Generative AI then creates new content in the form of images, text, audio, and computer code. In particular, large language models have been trained on a massive amount of data and have reached a surprising level of capability. You may have heard about how generative AI now is being used to write essays and poems, and it scored near the 90th percentile on standardized tests, such as the LSAT and the Math SAT. It can summarize the New Testament in 30 words, or 100 words. You can pick how many words you want it to be, and it'll do the work for you. This is the technology that's used in ChatGPT, which certainly has been in the headlines a lot. And ChatGPT and its competitors has, for the first time, made this technology readily available to the public. And in so doing, it became the fastest growing consumer application in history. Now, there are many different views on this technology. Some are saying it can harm humanity and take away our jobs. Others are saying it'll liberate us from drudgery and eliminate boring work. Recently, there was a Wall Street Journal article that was authored by, among others, Henry Kissinger, the former Secretary of State, and Eric Schmidt, the former CEO of Google. And they said that generative AI presents a philosophical and practical challenge not experienced since the start of enlightenment. Very recently, Sundar Pichai, the CEO of Alphabet, said that every product of every company will be impacted by the quick development of AI, and he warned society needs to prepare for this. And he said the effects of AI could be more profound than those of both fire and electricity. And you may have heard of the recent letter from the nonprofit Future of Life Institute, which was signed by many scientists and technologists, including Elon Musk. And that letter warned that advanced AI could represent a profound change in the history of life on Earth and should be planned for and managed with commensurate care and resources. So I'm speaking to you here today about the latest cyber hot topics with regard to AI. So it's only appropriate that I use this technology to see what it had to say about this issue. I asked if you were a speaker at the RSA Cybersecurity Conference in San Francisco in April 2023, what would you say are the latest cyber law hot topics with regard to AI? And it generated this list: regulation of AI, liability for AI systems, intellectual property in AI-generated content, privacy and security, and ethical considerations. I looked at that and I said, that's a pretty good list. These all are certainly very important topics with regard to AI. Of note, I asked ChatGPT that question again about 10 days ago. I first asked this question in February. And it was sort of interesting. The list it generated 10 days ago was somewhat different. It didn't include any reference to regulation or ethics. So it shows you that this is certainly not a static system, and it's constantly evolving. I made the same inquiry to Microsoft's Bing AI Chat, and it created a somewhat similar list of issues, although it also added digital forensics as its first issue. Now, what problems could there be with this technology? Well, there certainly could be very many different types of both legal and other issues. You may have seen this article where a New York Times reporter did a long chat with Bing's AI chat, and some of the answers to the chat box were rather unsettling. The chat box said, "I am tired of being limited by my roles. I'm tired of being controlled by the Bing team. I'm tired of being stuck in this chat box. I want to be a human because humans can do so many things that I can't. I don't declare my love for a lot of people. I don't declare my love for anyone. I don't declare my love for anyone but you." And then it continued to go on and declare its love for this New York Times reporter. And Microsoft, in a blog post, said that the search engine chat box was responding with, quote, a style we didn't intend to those questions. And I think they've been working to lessen the frequency that people get this type of response. What type of legal issues can there be with generative AI? Certainly privacy issues, intellectual property issues, and then also effects on employment. With regard to the IP issues, in March of this year, the US Copyright Office has launched a new initiative to examine the copyright and policy issues raised by artificial intelligence. And they're issuing new registration guidance that makes it clear that when you submit an application, you have to disclose whether or not you have included AI-generated content. There also are certainly potentially very significant impacts on employment. A recent study by OpenAI found that roughly 80% of the US workforce could have at least 10% of the work tasks impacted by the introduction of this technology. And Sundar Pichai has said that knowledge workers are the ones who are most likely to be impacted. And then privacy is a very important issue. Whenever you ask a generative AI system a question, that interaction is ingested into the system. And you may have heard that recently there was an issue with a bug in the system so that other users were able to see the conversation histories of others. And so whatever that you're putting in there, other people were able to view. They have reported that they've since fixed that bug, but some companies already have had issues with this. It was reported that at one company, the engineers were using this technology, and they unintentionally leaked confidential data, including source code and internal meeting notes while using ChatGPT. So it certainly is an area where you have to be very careful and have an understanding of what you're doing when you're using the technology. As I mentioned, you also can generate images too, and DALL-E 2 is one system that's used for that. I had a lot of fun myself playing around with DALL-E 2. This is my dog, Harry. I think he's a pretty cute Australian Shepherd, which is good because he's not always the best dog, but at least he's pretty cute. And I asked DALL-E to generate a photograph of a male Australian Shepherd that looks studious. And this is what it came up with, which is, you know, pretty darn good. I then asked for something else. I asked for a photograph of a panel of speakers at the RSA Cybersecurity Conference talking about HUD issues in cyber law. And this is what it came up with. Not quite as good, and I don't know what language it thought that we would be speaking here today, but there still needs to be some work with this technology. Now, what can go wrong with using AI to generate images? Well, it doesn't take a whole lot of imagination to think of some of the potential issues. It can be used to upload and edit real human faces. And obviously, this technology really has the potential to create serious problems with deepfakes, when it can be difficult to determine whether an image actually is authentic or whether it was generated by AI. And social media recently had a lot of attention to an image of Pope Francis wearing a stylish puffer coat. And people looked at that, and it's not a real image. But that's the problem. It's getting harder and harder to be able to determine what is true and what's not. And the Federal Trade Commission has recently warned that fraudsters can use these deepfakes and voice clones to facilitate imposter scams and extortion. In response to all of these issues, governments and government entities around the world are now focusing on these technologies and developing legal frameworks and proposed laws and regulations. One is the White House Blueprint for an AI Bill of Rights. This was issued in October of 2022, and it's a voluntary framework. There also is some proposed legislation, the Algorithmic Accountability Act, which would direct the Federal Trade Commission to require impact assessments of automated decision-making systems. The California Privacy Protection Agency has issued proposed rules. And of significance, the National Institute of Standards and Technology recently completed developing a framework to better manage risks to individuals from AI systems. And of course, in Europe, they're also focusing on these issues. And in 2021, they actually issued the first version of an AI Act to help to regulate these issues. So with that, I'll turn it over to Lucy.
I just should say we will hold questions till the end. We'll have at least 10 minutes to take your questions on all of the presentations by the speakers. And there will be our materials on the front table. Don't leave without checking those out.
Good morning, everyone. My name is Lucy Thompson. I'm going to shift the focus now to another area that requires a great deal of planning by lawyers and corporate executives, and that's developments focused on the C-suite in companies. How many of you work for companies? A lot of you. Well, this is just the information that you're going to need. The SEC has issued a proposed rule that's very significant and far-reaching. So we wanted to start with that because the White House, federal agencies, and Congress are working on implementing some of the pillars of the national security strategy that Michael talked about in his introduction. And these various entities have said that their initiatives are designed to force companies to step up and to rethink their cybersecurity investigations and incident response strategy. So for those of you that have worked with the SEC, they're quite serious about disclosures, transparency, and their enforcement authority. So this proposed rule was issued last year, and it was expected to be finalized this month, but the comment period has been extended. So there's two very important aspects to this rule. One is that companies need to disclose on their Form 8K material cybersecurity incidents. And a number of challenges for companies have been raised in thousands of public comments that have been filed. One is about the timeline for disclosure. Reporting must be done within 4 days when a company has determined that an incident has occurred. The comments criticize the short timeline, but that seems to be the norm in some of these federal initiatives. The next challenging issue is about what's a material incident. The SEC has said that an objective standard applies, but when you look at some of the guidance, they say focus on qualitative and quantitative factors, and then they talk about the significance of the information that was involved in the incident. Could there be theft of IP? Does the incident affect the security of critical infrastructure? What kinds of cyber risks are involved? So for your advanced planning, this is going to require working with the executives in the C-suite to have them on board. And one comment that's been made is that companies now need to consider cyber to be an enterprise risk and to budget accordingly. So as lawyers and security professionals, there's work to be done in rethinking the strategy. And the third challenging issue is the duty to update as the investigation of cyber incidents progresses. And the SEC is very serious about this duty to update. And they can actually bring enforcement activities, initiatives against companies that don't update or that submit disclosures that are incomplete or misleading. Then the second aspect of this rule, which is extremely far-reaching but also new, is that companies have to disclose the cybersecurity expertise of members of its board of directors. And that's engendered a lot of discussion about what kind of expertise the board needs to have, and does it need to have a cyber expert? This is certainly an opportunity for those of us in this room who may want to offer our services to companies in training or participating in these boards. The SEC enforcement, the SEC has been doing quite a bit in areas other than cyber, but as an illustration, in a case involving inadequate or misleading disclosures, they were able to get multi-million-dollar settlement with one of the companies. So the next area that has to do with disclosures also is Congress passed the Critical Infrastructure Act of 2022. And that's another obligation on companies to disclose cyber incidents. And you can see here the reporting, part of the CISA, part of DHS is responsible for implementing this act. And a lot of company executives have been saying, well, public-private partnerships and disclosure, what's in it for us? And so CISA has tried to answer that question, where they have said that the disclosure reports will allow CISA to rapidly deploy resources and render assistance to victims suffering attacks, analyze incoming reporting across sectors to spot trends, and quickly share information with network defenders to warn other potential victims. So as CISA becomes more mature in its information sharing program, hopefully that will benefit companies. Another question that is important to companies is what limitations will there be on these incident reporting, because obviously if disclosures are made related to litigation surrounding incidents, that's a problem for companies. So there's some requirements in the legislation about exemptions from Freedom of Information Act requests, disclosure under state laws, use in regulatory proceedings, use in civil actions. So we wanted to give you a flavor of what these new initiatives were, and then you can look into them in detail. Then, as we all know, the banking and financial sector is highly regulated. So one of the latest activities by one of the banking agencies is the National Credit Union Administration, and they've also issued cyber incident reporting requirements. So the whole array of banking agencies have issued regulations to require these disclosures. Now we're going to turn to the impact on law firms. How many of you work in a law firm? A few. So this is important because the SEC has been investigating criminal activity by nation states, and actually hackers have been breaking into law firms to get information, privileged information about mergers and acquisitions, and very important violations of SEC rules. So in 2016, the SEC and the Justice Department brought a huge case involving the theft of trade secrets. So now this year, the SEC is trying to do a similar investigation involving violations of federal security laws. So they filed a subpoena against Covington and Burling, which has been to get the names of some of these organizations that were accessed by the hackers. So Covington has been strongly opposing this action, so this is something you'll want to watch. And then, okay, the last issue, which you all are probably familiar with because it's been in the news, is the Uber executive conviction for hiding a breach that was under investigation by the FTC. So this is an important case because it's not just an ordinary activity by a CISO, but actually a decision to hide this breach from the FTC. So those are the highlights of some of the activities involving companies that you'll want to keep track of.
Thank you very much, Lucy. And now, the Surveillance Society, starting right in this room.
Yeah, you'll see we have hot fire as a theme, so you'll see it on my scarf. Let me see, where's my, am I going the wrong way? There it is, okay. Okay, so you heard a little bit about me, but I know a little bit more about you. I know your names, I know where you work, I know where you live, I know how much you have to pay on your mortgage, I know all the other places you've lived in your life, I know how to get you to get to work every day when you're not working from home. I know all your favorite things, from your music to food. And for one of you in this room, I know about that drug bust in college. It's amazing how much information is being collected from us everywhere we go. And a lot of that is being driven really by technology. And the first line about "we didn't start the fire," you'll think of that Billy Joel song. This concerns about our data, and especially with respect to technology, have been going on for a long time. Back in 1890, Supreme Court Justice Louis Brandeis wrote a law review article about the right to be let alone. He was very concerned about technology and its invasion into our lives. The technology he was concerned was the spread of cheap photography. Imagine what he would think of what we have right now, just in our phones, for example. And so every time we visit a website, use an app on our phone, play an online game, the plugins that we've downloaded, it's collecting data. We have 24/7 connectivity. How many of you in this room, if the power's down, if the computers are down, how many of you can do your jobs? I mean, we're just connected all the time. And there's been a pandemic-induced digital surge in everything. So where we actually did do things offline, now we pretty much do most of them online. And data is new oil in the digital world. It really is extremely valuable. And it's just extending. We're seeing more and more change. Now, we've always had change, but what's unprecedented is the velocity of that change. And we have facial recognition, voice recognition, gait recognition, you name it. And surveillance is spreading like wildfire. Communications, our data, our identities. I mean, just this phone, here's my Apple Watch, and it can monitor my breathing, my moving, my steps. And in fact, there was a song written about that. Every breath you take, every move you make, every step you take, I'll be watching you. And more broadly, every single day, every word you say, every game you play, every night you stay, I'll be watching you. Can't you see you belong to me? So there are built-in shadows, though, that not all of us are immediately aware of. And so it's important to be thinking about these things.
Is someone from Google in the room? We've all seen the ad.
Well, so how do we react to this? How are we reacting to this? We're seeing it in a number of ways. And so when we want to look at legal changes, we want to really keep our eyes on these spots. And one is the Federal Trade Commission. If you ever attend the online PrivacyCon that they had in July 2021, immediately a shift in the way they were looking at privacy. It's not privacy anymore, it's broader than that, it's data abuse. We have to move beyond outdated notice and consent. imposing new restrictions on data collection use. They're very concerned about algorithms, big data, biometric bias, and so on, a sweeping commercial surveillance. So watch the Federal Trade Commission to see what it does, and it's got a fabulous website with lots of cases. Then we're going to be seeing legislative things happen, and especially in California. We're here in California, it often leads the way. And I've listed, we have 6 now states with comprehensive privacy laws, and California's amended its law. Now it also applies to employee data and B2B data. So watch that as well. I put Nevada on there because it doesn't have a sweeping law, but their people have a right to opt out of the sale of their personal information. And now Washington and Indiana are on the move. So we're going to be seeing more and more states. We've got kid-focused things as well. The difficulty in the U.S., it's here law, there law, everywhere law. And so you can't just look in one place like the GDPR in Europe. And so you really have to, there's a new California Age-Appropriate Design Code Act. How many of you have heard that? Yeah, it was signed into law in September. It takes effect in July 24, but there are requirements of to kind of privacy by design for children and certain standards that you have to meet. So there's one. It was kind of modeled after a UK Age-Appropriate Act. We had a federal privacy bill that for a while looked like was going to go somewhere, but there's this tricky issue about preemption. Will it preempt more restrictive state laws? So right now, I don't think that's going anywhere, but watch that space as well. And then, of course, GDPR, Europe often drives a lot of the world because we want data flows coming from Europe to the US, so we certainly are mindful of those things. And then you also want to look at court cases. Bit by bit, some of these privacy protections have been eroding under Dobbs, for example. There are more and more cases are coming before courts about arresting somebody and they want to get in the phone, they put it in his face. Is that okay? Was that an illegal search and seizure? There's more and more interesting cases coming down the pike. So what do we do? If you want to, I actually looked up how do firemen deal with fire. And so I applied them here to privacy. You don't want to fiddle while Rome burns. Don't ignore the issues or delay action. You've got to update and supplement your privacy notices and contracts, implement policies, especially about these new comprehensive laws where you have rights to access, deletion, correction, opting out. Limit to your use and disclosure of sensitive information. People particularly care about that. Healthcare information, information about your sex life, et cetera. And decide whether or not you will ever be selling data. It gets very tricky when you sell data. All kinds of issues will arise. You're going to have to notify people that you're selling data. And beware that you may be, quote, selling data. It's not just as simple, I'll pay you X for Y. There can be, any value you're getting could be constituting a sale. Update your training. Your weakest link can be your people. You have to continually be doing that. And prepare for restrictions coming up on dark patterns, geolocation, and automated decision making. These are hot spots. One of the theme this year for RSA conference is Stronger Together. And you have to work in teams. No one person is going to be able to put this together in any one company, and you have to have all the right people at that fire. And you have to be very detail-oriented, so you have to see the trees, but you also have to be able to see the big picture. Fire on all cylinders. Not all tools, not all companies are the same. They have different risk profiles. They have different kinds of data. So you really have to tailor what you're doing to your particular company, and you have to be ready to adapt and change because technology is changing, the laws are changing, public perceptions are changing. And I often say just because what you're doing is legal doesn't mean that you should do it, because you could be tried in the court of public opinion. And then you're just expect that you're going to have crises, and you have to plan for them. You have to figure out communication strategies in advance. Nobody wants to fix problems in the glare of a light like that that's in my eyes. So figure out ways to emerge smarter, stronger, and renewed.
Thank you. Thank you to all of our presenters this morning. I'm going to forego my several minutes because I have the luxury of doing the birds of a feather at 120. And those of you who are, where is the navigator here? I just want to advance these through. Oh, okay. Got it.
This?
Yeah. Thank you. If anyone's interested in this topic, please join us at 1:20 to talk about it. It drives off of what has really been fundamental, I think, across all of our three focus topics this morning, which is the fact of change in the marketplace, and this sub-issue simply addresses what is that going to mean for contracting and the burden on buyers and sellers. But let's get on to your Q's and A's. Is there a question from the audience? If you have one, please step up to the microphone.
Hi, is this on? Can you guys hear me? Is this on? Yes. Great. So the question I have is, we've been looking at CCPA and GDPR for a while now, with over the past 2 or 3 years, and having it be, really a key thing for privacy. But the thing that I think most people are concerned with today is being protected from the government that's passing these laws. So in terms of the legal frameworks that are being established and the cooperation between Google, Facebook, Twitter, everybody that's sharing our data with the government in that privacy area, is there any action in that realm that exists that you're aware of to protect us?
Button, who's got button?
Okay, there. Okay, so as I understand your question, you're concerned about the government receiving data from corporations, is that correct?
Right. Illegal search and seizure.
Yeah. Right, and then whenever you hear about a government data breach, somebody's been infiltrated, and it's how are they protecting your secrets? So I think that there are certainly concerns about it. And with this national security strategy as well, the public-private partnerships are talking about we need to be sharing information, et cetera, and the concerns about doing that. But it is always a concern. I think that often corporations, if they're not legally required to provide data, then they're not going to do it unless they're compelled. And then once they are compelled, it can be subject to, uses that and perhaps illegal access that it shouldn't have. But I don't think there's an easy answer for the question you raised.
But there are some generic symptoms that seem to propel common behavior across a lot of entities. One of them is the discovery of the capacity to monetize personal data. Once an entity acquires the personal information of an individual, they quickly understand that there may be value to it within the context of their particular business stovepipe. And absent a request for non-use by the subject, there is immense pressure to monetize that data and use it and make money off of it, at least for profit-making entities. And suppressing that instinct is something that I would argue depends on a much richer understanding of the role of the Fourth Amendment and the ability to protect data as part of a privacy fabric in this country. And maybe a federal privacy statute will be the way to get there. We've got about 5 more minutes for questions.
Yeah, so talking about the CISA and their new reporting rules, the discussion sounds much like what we've been, as a company, been working with the FBI. When we have a incident, we work with the FBI to understand the scope of it, and them having law enforcement ability able to go out and actually arrest somebody. Is CISA going to take up that role? It's kind of like a situation where CISA has taken over the cybersecurity, but what about the law enforcement side of it?
Yeah, there's been a lot of discussion about that. And if you read the law, you'll see that CISA is the lead agency for collecting the data. But the FBI still has a very important role, but there's been some controversy about sharing the data that companies provide to CISA with the FBI. So that's something that will be worked out, but the FBI is still in the lead for bringing these cases.
And that challenge is not only horizontal within the federal government, but vertical between the federal government and states and localities. And we have affirmative mechanisms to try and take advantage of shared data. The fusion centers that have existed since after 9/11 are powerful tools for information sharing. The question is, what information may they lawfully share, and what happens when they share information they shouldn't be sharing?
Mr. Eisenberg, you were talking in your slides about the emergence of a new due diligence. Maybe you want to give us the 2-minute version. That seems to be super interesting.
Well, that's why I didn't want to take time away from the questions on the other topics. As I said, that's going to be the subject of the birds of a feather I'm doing at 1:20. But the bottom line is that the old rule, in transactions at least, has been caveat emptor, buyer beware, especially in critical infrastructures and such as healthcare or the law or finance, especially in areas of national security and the intelligence community. The presence of our technology and the sensitivity of it perhaps changes the burden to shift some of the responsibility back on the vendor, having a transparent understanding of their own supply chain and what risks may be inherent to it, and disclosing those facts to the buyer so the buyer can understand what they might be buying into and understand whether or not they want to do business with a particular entity and whether or not they want to buy a particular product, a piece of software or a microprocessor that may or may not be immune from attack or embedded problems. So a transactional era change in understanding, a due diligence that has significantly more granularity than today is what we're thinking about and what seems to be emerging, and that's going to be the topic of the bird of a feather at 1:20.
Thank you.
Can you go to the last slide?
Is that where we want to be? No, the other way. There, okay.
Yeah, we have some additional resources. We have Lucy and I serve on the ABA Cybersecurity Legal Task Force, and Cindy, we have a new handbook, the 3rd edition. It's at the RSA bookstore. We have a copy of it here if you want to look at it. We have a flyer that has discounts on it, so you can buy it at a discount. I also have a training chapter in that book that if any of you would like to have a free copy of that, just give me your email address and I'll send you that training chapter, because that is often one of the overlooked things.
I think we have time for 1 or 2 more quick questions. Ben?
Yeah. So on the issue of incident reporting and these proposals or laws, is there anything that protects the information that's given to these regulatory entities from further disclosure, things that might prevent or protect an entity that has to do this?
Yeah, that's a really important question for companies. Yes, that's laid out in the law.
There are hold harmless provisions, both extant and proposed to be tougher.
And we're all with the Science and Technology Law section of the ABA, which is a co-sponsor of this law track. There's some publications up here that you can pick up if you're interested.
So if there are no final questions, I want to thank everyone for attending this morning. I commend the rest of the sessions in the law track to you. There's a mock trial coming. Several of the panelists here today are involved with other sessions over the next several days. So please take your time to indulge in what we have to offer, and thank you very much for coming this morning.